take short. You are live. Okay. All right. Good morning. It is May 21st in Senate Judiciary. We have Marshall Paul from the Attorney General's office with us.
Thank you very much. Excuse me. So, here to justify that one particular section of H109, which is section 38, the Child and Parent Legal Representation Task Force Board. So to begin with, I just want to clarify just from the outset that this is sort of a strange position for us because we oppose this provision, and that might seem odd because it's merely a task force study committee. And so what I'm going to do is I'm going to explain sort of the origins of this bill and the problems with this bill, and which is now a provision in H109. It started as an independent bill, and why we oppose it. And so with that, just to start off, I want to start by just explaining a little bit about CHIN's representation in Vermont. So if you're not familiar with CHIN's, CHIN stands for Child in Need of Supervision, and it is the sort of catch-all term that the state of Vermont applies to all child welfare cases. So these are cases where the state is intervening into a family because there's allegations either of abuse, abandonment, neglect, truancy, or a child who's beyond the control of their parents. So this is separate from the delinquency system, which is children who are accused of committing acts that would be crimes if they were adults. And they go through a sort of probation system. This is different. This is family intervention. This is the state stepping in and saying, we believe that there's a child who is in need of care or supervision from BCF, and it's this process that we're talking about here. So in these cases, all parties are represented. Children are represented. Each parent is represented. The children may be represented separately if their interests are divergent, which happens pretty commonly actually in these cases, which means there's a lot of lawyers in these cases. So just to give you an example of a typical case, one that I was in court yesterday, we had a case that has two lawyers for the state, one attorney general and one assistant attorney general and one state's attorney, and four different attorneys representing parties because there's a mother with two children who are represented by one attorney, and they have two different fathers who are represented by two separate attorneys. So you can see how, just in a very simple case, even just as a starting point, you start out with a lot of attorneys. And that's why we have a system in Vermont where we have two primary forms of representation: staff attorneys and conflict contract attorneys, because we have attorneys in our offices who will represent one party in the case, but they can't represent anybody else in the case, and nobody else from our office can represent anybody else from the case because that would be a conflict. And so that's where we turn to our conflict contract system, who are private attorneys who have contracts to provide representation where our office has a conflict. Does that make sense? Okay, so yeah. Excuse me. About 15 staff and contract public defenders representing parents and children in CHIN's cases. Those would be the ones that we directly supervise and work for us. And then our conflict system is about 40 more people. So I'm going to make through this pretty quick. I've uploaded the PowerPoint so that you can look at it afterwards. I've got a lot to go through and not enough time to get through all of it, so I'm going to try to move quickly. So I want to talk about where this provision came from. This provision originates with a bill last biennium called H398, which was a bill that was very much targeted at taking the representation of parents in particular away from the office of the Defender General. So that was a bill that was proposed to create a group consisting of pretty much everyone except the Office of the Defender General, and specifying that members of this committee could not be people who were associated with the Office of the Defender General. And it was tasked with designing a system of representation to replace the Office of the Defender General in child welfare cases. That bill did not get heard at all. It stayed on the wall and died on the wall. The new version of that bill was produced this year, which was H 193, which was a toned down version of H 398. It did basically the same things, except that it removed the provisions that said that nobody who's affiliated with the Office of the Defender General could be on the committee. It carved out a spot to say, okay, we'll have a representative from the Office of the Defender General on the committee. But it was still to create, essentially to examine a new system of representation. Those provisions are now being what's rolled into the S109, the miscellaneous judiciary bill. So when the House heard testimony about H193, which they ultimately rolled into S109, they heard a lot of statements that were completely incorrect. And I need to address those because those really formed the basis of the House's desire to pass this bill. And they were so incorrect that they really need to be addressed point by point. And if you want to, you can go back and watch the testimony in the House. It was pretty extensive where all of these points were made. And you can also watch my rebuttal testimony, which I'm giving sort of an abbreviated version of today. So the points that were made were essentially the contract attorneys. This was all very much focused on the conflict contract attorneys. So that's what I'm going to focus on in this presentation. The combined contract attorneys were taking Chin's cases and that they were underpaid, could not support themselves on their work, and so they were taking lots of extra cases. That they did not have investigative resources, that they did not have interdisciplinary practices, that they're not supervised, that there's no standards, that there are no performance measures, that there's no mandated training, and that we are not pursuing funds to expand interdisciplinary representation. Those were all statements that were made in support of H193, which is now being rolled into the miscellaneous judiciary bill. And I want to go through them one at a time, but quickly. So first of all, our Chin's attorneys are not underpaid. Our staff attorneys are paid exactly.
I don't believe we're going to be having DCF at 9:30. So if you need a few more minutes beyond 9:30, you don't have a rush.
So our staff attorneys are paid exactly like our criminal attorneys, same step system, no difference. The contract attorneys, we pay on a flat rate system per year based on historical caseload data, and I'll talk about how we calculate caseload in a minute. And we calculate it based on lawyer equivalent caseload, which is essentially the number of cases of a particular type that one lawyer should be able to handle in 1 year. And what we are paying on the average right now for our contract attorneys is $227,000 per lawyer equivalent caseload within our child welfare contracts. So that's if you were to include our criminal contracts in there, the number would go down a little bit because our per LEC payment is actually higher in the juvenile system than in the criminal system. But so if you take out just our juvenile contracts and sort them on a per LEC basis, we pay about $227. Now, to be fair, that sounds like quite a bit. It's more than I make. When you take into account the fact that these are contractors who have to run an office, they have overhead, it is, we think, a fair amount. It's not a low amount. It's also not a high amount. It is what it costs to run an office, have some overhead, and practice law for a year. So, in terms of how we calculate caseload, this is another thing that was addressed in the statements was about how we calculate caseload. We apply the National Advisory Committee on Criminal Justice Standards caseload, but we modified it. So that was a caseload standard that was set a long time ago, back in the early 80s. And it said that no attorney should have more than 200 added juvenile cases per year. We don't believe that that's reflective of modern practice, so we've changed it. And so within our system, we've changed it to 150 added cases per year, which is the same as what felony criminal attorneys said. And we've changed it from added cases to added case events. So what we do is we measure, where instead of measuring a Chin's case as one case, we measure the filing of a Chin's case up to the point of disposition as one case, and then every post-disposition event as another case, and then if a case goes to a termination of parental rights, that counts as 3 more cases. And so that means that, for example, one case that is in a county where cases tend to be resolved fairly quickly and easily through reunification. There's some counties where the rates of reunification are much higher than others. There might be a case that lasts just as long as a case in another county, but is actually fairly simple. It goes through, a very, standard process from temporary care to disposition to reunification. And there may only be 3 case events counted in that case. In the same period of time in another county where a lot more cases go, definitely contested termination of parental rights, or where you have a lot more contested hearings, a case might take 9 or 10 case events to resolve in that same period of time. And that's why we think it's more important to measure added case events than it is to measure pending cases. Now, that said, I can talk about caseload measurements for like a day if you wanted me to. I get really geeky about it. And I can tell you that if things are all working well, either caseload measurement should give you a good sense of how much work lawyers are doing. And when things go wonky, sometimes those caseload measurements diverge. And depending on why things went wonky, one caseload measurement may be more accurate than another. In our experience, measuring added case events gives us a much more accurate representation of the workload that our lawyers have, because we have such different practice county to county in Vermont. In other states, there's a lot more uniformity of practice county to county. They have a lot more statewide policy making at the Department of Children and Families level. And so cases proceed in a lot more of a uniform manner. And so you can really compare pending cases from one county to another county, where in Vermont, we have very different practice from one county to another. And that's why we think looking at added case events is better than pending cases. So we use that information then to calculate pay. So we look at the last 3 years of a contract's caseload data. And so the way it works is the contracts are in tiers. There's the first people to get assigned are the staff office. And then the next person to get assigned has the first tier contract. Next person to get assigned has the second tier contract. We usually in most counties have 4 or 5 tiers of juvenile contractors. And obviously the ones who are at the top of that list get more cases than the ones who are at the bottom of that list. And so that's the way we essentially calculate the rate of pay, is we look at the top tier contract and we say, okay, how many cases did they get assigned 3 years ago, 2 years ago, and last year? And we look for trends. So if they have if it's a contract where they're getting assigned 0.25 of lawyer equivalent caseload in year 1, 0.35 in year 2, and 0.45 in year 3, we're going to assume that that's going to be an upward trend, and we're going to write the contract for probably at 0.6 for the next year. And then we look at that and we multiply that fractional LEC times our target per LEC rate, which is $185,000. Then we make adjustments based on people's level of experience, willingness to take contracts that other people don't want to take. That's usually in remote counties, things like that. And we might adjust the contract because of that. So just to give an example, this was just one of the contracts we calculated out last year. This was an FY 2024 contract. We looked at one contract where the caseload had gone up over the last 3 years from 0.35 to 0.6. So we wrote that contract as 0.75 LEC. When you multiply 0.75 LEC by 185, that gets you 139. We made some adjustments because this was somebody who was taking a contract in a remote county and was going to have to do a lot of driving to get there. And we're always grateful to the contractors that are willing to work in the remote counties. And this was a contract with a lot of experience, so we gave a bump for that. So we made that $155,000 contract. That's the way these contracts get made. That's how we determine how much our attorneys get paid. And that's why we do not believe that our attorneys are underpaid at this point. When you compare this to other states, It's hard to do, especially because most other states don't have quite as organized a system of providing representation in child welfare cases. If you look at Maine, for example, they have no system at all. It's all ad hoc court appointments. If you look at New Hampshire, it's a little bit more organized than that, but they certainly don't pay nearly as well as we do. They pay on a per case basis, not on a flat rate contract basis. Again, we like the flat rate contract basis. We find that it attracts more people to be contractors because they can count on how much money they're going to make. It is you're going to get your check for X amount per month, every month, no matter how many cases came in. So for example, during the pandemic, when the intake of cases slowed dramatically, our contractors were still getting paid all along. Where in a lot of states, Connecticut in particular, I was in communication with Connecticut's chief juvenile offender at the time. They were losing a lot of contractors who had to take other jobs because they had less cases coming in from the state. And so they had to drop their contracts. So from our perspective, it's been really helpful to structure payments this way. It helps us retain contractors. So moving on to the idea that CHIN's attorneys don't have resources, in particular, investigative resources. I just want to be clear that our CHIN's attorneys have access to all the same resources that our criminal attorneys have access to, plus some resources that our criminal attorneys don't have access to. And there is no limited list. It's not like we have a list that says, here's all the resources you can have, and if it's not on this list, you can't have it. Instead, what we have is we have an expert services request form that any one of our attorneys can fill out for any case. And those forms, if they're about juvenile cases, they come to me for approval. If they're about criminal cases, they go elsewhere. I approve nearly every request that we get because our attorneys are pretty good at making requests, and they typically don't make frivolous requests. But so I approve requests all the time for investigators, social workers, family support workers, forensic investigators, doctors, child abuse pediatricians, all kinds of experts and services that we move into this. In addition to, we've recently really picked up on using some paid, they're not really social workers, but case managers that we're using to do, in addition to the social workers that we have, we've got an organization that we're currently using pretty regularly that's providing essentially high-level case management for kind of our most complicated cases. Those are really ones we apply in the cases where we've got lots and lots of.
Just one question for you that I want to make sure the committee is aware of. So you mentioned overhead for private contractors, and obviously expert witnesses can cost quite a lot as well.
Oh, yeah.
Is that something that the private attorneys have to pay for, or is it something that that your office pays for?
Our office pays for it. And that is, I don't think anybody could be a private. I mean, there's cases where the bills for experts, run into tens of thousands of dollars very easily. So we would certainly be expecting private attorneys to be paying that. So there's no limitation on the resources that are available to the CHIN's attorneys. And it's very rare that we reject somebody's request for an expert or an investigator. Typically, when we do reject it, it is more a matter of form than substance. It's people don't provide us enough information in their request form, and we reject it, and they provide us more information, and we end up accepting their request. People are pretty good at making requests that are legitimate. In terms of the access to social service providers, that's something that we've done very specifically for more than a decade now. We have a family support worker program, which consists of about 24 family support workers around the state. Some of them are ad hoc, meaning that they can be requested by any one of our attorneys. Some of them are embedded within particular offices and we work with particular attorneys. They are a wide variety of people. Some of them are licensed clinical social workers. Most of them, the sort of plurality of the group, are retired DCF caseworkers. And then we have other backgrounds, teachers, coaches, and honestly, looking at anybody to try who seems to have some skills in the world of connecting with our clients and interfacing with social service providers and community. So just to give you an example, we got one family support worker who is a miracle worker when it comes to housing issues. And it's not that she has any particular qualifications. I honestly think that it's mostly because she's a member of a very large church, and she just leverages her church whenever we have housing issues and we get a case with her on it. She's able to find housing for parents who have struggled to find housing for years. And she managed to find somebody in the basement apartment that they'll rent out every time. Like, our family support workers are a pretty incredible group. Some of them are real generalists. They work with families on sort of kind of all the issues that they have to deal with in interfacing with the system. So what I mean by that is they do a lot of work. Our clients will get essentially a list of tasks to complete by DCF. They'll be told, you need to do a substance abuse assessment and engage in substance abuse treatment. You need to engage in a parenting assessment and follow any recommendations. You need to engage in a mental health screening and follow any recommendations. And that can all be really hard for a client in our client's situation to put together, to figure out how to do that. And if somebody just directs you to engage in a substance abuse screening, if you don't know how to go about that, you're really stopped from the beginning, stopped from day one. And so what our family support workers do is they facilitate all that work. They help our clients facilitate a substance abuse evaluation if that's what's required. They find things that DCF has not found. And they do that. So they'll go through a list of screenings with our clients and say, you know what? Nobody's really identified it, but I think you might qualify for a disability. And I think we need to hook you up with disability rights for bond, get you connected with SSRI, get you connected with a disability rights provider, things like that. That's what our family support workers do. They also help our clients interface with DCF. A lot of our clients have contentious relationships with DCF. And so a lot of times what our family support workers do is just show up at the meetings with our clients, be there with our clients, to kind of help diffuse any tension that builds up. And one of the things I tell to our family support workers all the time is, I just want somebody for my client to be able to vent to after a meeting. So they go into a meeting, and instead of venting in the meeting and saying some, expressing their frustration in the course of the meeting, they can come home afterwards, call you and tell you what frustrated them about the meeting. So that's our family support worker program. And we assign family support workers whenever they're requested. They can be assigned for attorneys who represent both parents and children. And we use them very extensively. It's a very successful program, one we're very proud of. And even though we only receive about $150,000 a year for that, we spend extra money on that because it's a program we really believe in. That one is just critical to the function of our office and to the representation of our clients and to the process of our attorneys. So we're really proud about that. And the idea that we don't have interdisciplinary practice, meaning practicing alongside social work providers, just as incorrect. So also the idea that the law attorneys are not supervised it's got a grain of truth to it in the sense that no attorneys are supervised because by the rules of professional conduct, by our ethical rules, attorneys are required to operate independently. We are a profession, meaning that we cannot benefit from the protections of corporate structures. We are all, I don't know why my screen just lost share. Let me try to share that again. And so no attorney can actually be told, here's what you must do, here's what you must not do. You can tell an attorney, you can train an attorney and say, here's how you do your job. And then how they do their job is up to them. And if you see them doing a bad job, you can fire them. But it's not like running a coffee shop where you can say, hey, you go do this. It's part of the nature of being an attorney is you have a professional obligation, a fiduciary obligation to your clients. no matter what your bosses tell you, your first obligation is to your clients. So to the extent that that is true of all attorneys, nobody is supervised in the sense that a employee is directly supervised. But to the extent that by supervision we mean responding to complaints, addressing concerns, investigating complaints, and making human resources decisions based on the performance of our attorneys, we certainly do that. So to begin with, we respond a lot. I'm the person who handles complaints in our office. Complaints come to me. We certainly respond to every complaint. In fact, some would say we go overboard. The judiciary gets annoyed at us at times because anytime that somebody complains about one of our attorneys, I order transcripts from the hearings that they've been in so that I can review everything they've done in court. That's where I often get some pushback from the judiciary. Calls me to be like, why are you ordering transcripts in confidential juvenile cases that you had nothing to do with? And when I explain that I'm responding to a complaint, they always say, okay, and let me move forward with it. But we do all that. I call up and I investigate. I talk to the clients and find out, I get their side of the story. I talk to the attorneys and get their side of the story. If there was other witnesses, court clerks, courtroom officers, I go to everybody. I write up a report. I bring that to my boss, to Matt, and we deal with it as it needs to be dealt with. And that can vary case to case. Sometimes it's as simple as calling an attorney and saying, hey, this client's not hearing back from you. Can you give your client a call back? And we sort things out that way, and it's that simple. Sometimes it's a lot more serious, and these types of complaints have led to people losing contracts before. So everything in between, from that, a complaint resulting in the termination of a contract to a complaint resulting in just a phone call and say, hey, your client's just not getting a call back, and I know you're busy, but just give this client a call back because the client really needs to hear from you. So anything in between. But every complaint gets addressed. I need a running spreadsheet. Every complaint is entered by date. It's always flagged in green, yellow, or red, depending on whether it's been resolved, is in the process of being resolved, or has some sort of a problem. And I can assure you the only complaints that have not been resolved, except for ones that have come in within the last week, are ones where there's some kind of a problem where I can't reach the person who made the complaint for one reason or another. Other than that, we resolve every complaint. So the idea that our attorneys are not supervised and that there's no response to concerns about them is just inaccurate. As far as there being no standards for attorneys, that's also inaccurate. There's two primary sets of standards for attorneys who practice child welfare law. There's the ABA standards and the NACC standards. I won't get into the details because they differ in ways that only people who are really keen about child welfare law are going to care about. But because of the structure of law in Vermont, we feel the ABA standards are the more applicable ones. So that's what we train to, is the ABA standards. We teach the controversy by teaching people why we teach the ABA standards rather than the NACC standards. But it just isn't correct to say that there's not standards for attorneys in Vermont. We follow the APA standards for, it's actually two sets of standards. The standards for representing children in child welfare cases and the standards for representing parents in child welfare cases. The statement that there's no performance measures for children's attorneys in Vermont is inaccurate. We do our attorney evaluations on a 4-year basis. It says 3 years on the PowerPoint. That's a mistype. It should be 4 years. We are one cycle behind in that because we just switched from our old case management system, JustWare, to our new one, Logics, and our IT is still catching up with that. It's a nightmare, but we're going to be back on track this year to do our evals. Our evals are actually incredibly granular. And so the ones I'm going to show you are just contract attorneys in child welfare cases. And these are just the judicial evaluations. We also look at peer evaluations too, but we find that the judicial evaluations are the most valuable. And we use these to do both. So we do these on an individual basis, and I'm not going to show you that obviously because that's HR sensitive. And then we aggregate it all to look at on a sort of aggregate basis, how are our contract attorneys doing? And we use it for training purposes. And that's why we do it on a 4-year cycle, because that's basically our training cycle. We identify our points of weakness, and then for the next 4 years, we train on those points, and then we reevaluate. So if you look, and I'll go through these quickly, when you're talking about motions practice, we evaluate 4 different categories, and our attorneys rate them very good. 6 is very good, 5 is good, 7 is excellent. Same within the category of effective representation, we have 5 subcategories. Yes.
Who does these ratings?
Judges. So every attorney, we figure out every judge they've been in front of in the past year, and we send a survey to that judge about that rating. Some of the judges don't respond. If it's an attorney they've only seen once or twice, they'll just respond one, which is not applicable. But it's actually, we get a pretty good response rate from the attorney, from judges who are in the court with the attorneys on a regular basis, which is what we want. We send it to all the judges, but we really want them to respond if they have a good sense of that attorney's performance.
Is there any mechanism by which the people the attorney has represented rate those attorneys?
Not a rating system. We'd like to have that. We have a system where they get a pamphlet about sort of the process of representation and with our phone number called complaints. A rating system, something that's talking about it. And we really like to implement. It would be really interesting. We're talking about large scale, not just in the child welfare system, but across our system, criminal, juvenile, everything. It's an interesting part of it. Part of the trick in jurisdictions that have done that, and I'll be brief about this because it's kind of a rabbit hole, but in jurisdictions that have done that, part of the trick is getting equitable access to it. It's they did it in San Francisco, and one of the problems they ran into is they did it all online because that's sort of the easiest way to do it. And what they found was a lot of their clients couldn't or didn't access it. Now that was a few years ago, and I'm curious whether that's true now. I think a lot more of our clients have smartphone access than did 5 years ago. So I'm curious, I want to talk to people in San Francisco and see whether they're still doing the same thing. They were the ones that sort of started doing that, started representing about it at national conferences. It got us interested in it. But there hasn't been a lot of follow-up, and I'm curious sort of what's happened with their code themselves. So
Too, because a complaint-driven program, I think there's an assumption that if someone doesn't complain, it means everything's fine, which isn't necessarily true.
right, and that's why we do the performance evaluations, and I'm showing you just because I know this is massive that I could spend a day presenting about our performance evaluations. I'm just presenting some really aggregate numbers. These are just the averages of our juror contract attorneys, just the judicial evaluations. Part of the reason why what we have is actually much more expansive, much more granular, involves peer evaluations, efficiency, judicial evaluations.
No, I appreciate that. I also think it would be really important to have a sense of.
Now, and that's certainly part of our ongoing plan. I mean, as you'll see, we are constantly developing our evaluation system. So here's courtroom skills, another category with 8 subcategories, where again, we range between good and excellent, mostly around very good. And you can see in here some of the places where we've been refining our evaluation system, like question 7 is one that we added based on judicial feedback. We didn't have that in 2010, we added that in 2014. Same with, here's client relationship, professionalism. So we evaluate in all those categories. So the idea that there's not evaluations of our attorneys is incorrect. And we use those evaluations, like I said, for 2 purposes. For individual attorney visits, we use it to make decisions about contracting and training and remedial training. So there might be an attorney who's getting good scores in a lot of areas, but not good scores in their courtroom skills. And so we might send that attorney to a training, there's NACC courtroom skills trainings that we like to send attorneys to. We like to send them to one of those. Or if we identify an area where we see everybody is kind of over their blood, then that's going to become a topic of training for everybody. So that's how we decide what we're training on at our annual summer trainings. So that gets us into the issue of training. A statement that there's no mandatory training for the chains attorneys. Also just completely incorrect. So every staff attorney, training is mandatory because it's part of your job description. Every contract attorney, training is mandatory because it's part of your contract. It makes some exceptions. Because for me, rarely on a case by case basis. Obviously, not you fire somebody because they had a family illness or something, couldn't be there to train. But otherwise, these are treated as mandatory. We're just doing our registration for the summer training, and we just did the thing where we called every attorney who's on the list of mandatory attendees who didn't register to say, why didn't you register? And to make them all register. It is that mandatory. And so that is usually 3-day training in the summer. Past 2 years, that's been 2-day training because our training budget got cut during the pandemic and hasn't been bumped back up. So we'd like to get that back up to a 3-day training. It actually more than doubles the amount of training we can do because we have a few sort of mandatory things like legislative updates and appellate updates that take up some of our training time. So even though it's like a 2-day or a 3-day training, wouldn't be twice as much training as a 2-day training. It actually is. So we really love that 3rd day back. But it is 2 days of straight juvenile training. And then there's 1 day in the fall of in-person straight juvenile training. All of that is 100% mandatory. Then we have bi-weekly trainings that are done online. That's something new. We started doing that in the pandemic when we had to cancel our in-person trainings. We moved to online bi-weekly Zoom trainings at lunchtime on Fridays. We kept that going because we really liked it. Even though we reinstated our in-person trainings, those aren't mandatory because we can't actually control people's schedules on Friday afternoons. I had to miss this Friday's training, even though I had set it up and it's one I really wanted to go to because I was in court. So we can't make those mandatory, but we usually get 40 to 80 attorneys at every one of those. So we do have, it's not correct to say that there's not training for our chains attorneys. It's both mandated and optional. And it's good enough that we get attorneys from New Hampshire I pay money to come to our trainings because they don't offer trainings in New Hampshire. Honestly, I think in New England, the only people who come close to us for child welfare are Massachusetts has a great training program. Their CPCS. If we had the scale they had, we'd love to be able to do the same things they do. But they just have a really tremendous training program. They're who we sort of model what we're doing after. They're why we sort of developed our online bi-weekly trainings. That was modeled after CBCS's trainings in Massachusetts. So then there's the assertion that there's Title 40 money out there that the Office of the Defender General is not pursuing. And again, that's something that comes from a grain of truth, but it is inaccurate. So at the end of 2018, the Federal Agency for Human Services made Title 40 money available for parent and child representation. At that point, it had only been available for representation of the state. So if Title 40 money was used by state's attorneys and Attorney General's office, and also pay for foster care related services, but it couldn't be used for providing child and parent representation. That changed in 2018 by executive order on Trump's appointee to the Children's Bureau, Jerry Milner, who was fantastic during the time that he was at the Children's Bureau. One of the only time that I've ever seen the Children's Bureau talk about parent and child representation at all was when he was there. So tremendous time at the Children's Bureau, and they made 40 money available. We immediately started a process working with the other states in New England to figure out how to draw down that money. And we had basically 3 things that we wanted to draw down that money to do, because the feds were clear that that money was to be spent not to supplant money that you're already spending, but to expand programs that you want to expand. So in consultation with other states in New England and what they were getting approved by AHS, we identified 3 things, which were to increase interdisciplinary practice by getting more social workers, having more of them embedded in offices. It's great to have them available. It's even better when we have them embedded in offices. for uncollateral representation, like landlord-tenant representation, immigration representation, educational representation, and to create a pre-petition representation program. We had played around with this at one point when we had a small grant, and we did it with hospitals. We were asking hospitals to essentially identify families that would be at risk of coming into contact with DCF before they did. And we were getting representation for them prior to any DCF involvement. We think that could be a really successful, it's been done in other states, a really successful model. And that's what we're looking for with Title 40 money.
When you say hospital, do you mean like the medical center?
Yes.
Okay, because I was like, we don't have any children's inpatient.
We're actually talking about primarily pediatricians and OBGYNs. So we're talking about people who have contact with young families or emerging families, and who are and building partnerships with them where they essentially are able to say to their patients, look, you don't have to let me do this. There's no requirement for me to report anything. But I do think that you're a family that's at risk of coming into contact with DCF, and I could arrange a private consultation with an attorney for you, and they could help you try to sort of identify the things that make you at risk of having DCF involvement, and to sort of remediate those problems ahead of any DCF involvement, or get prepared for DCF involvement before it occurs. And that's a model, that medical legal partnership to identify families pre-petition is a model that's worked in other states. And we've sort of tickled around the edges of it in Vermont. We think it could be really, really successful because, in part, because Vermont has such a good system of providing prenatal care. In other states, there's a lot of people, especially people whose children wind up in DCF custody at a young age, aren't receiving good prenatal care. In Vermont, we've got Dr. Dinosaur as one of the best systems for ensuring that pregnant women get prenatal care. And so for us, as in terms of a of intercept, it's earlier than the DCF petition phase. It was the obvious answer, and we still think it is. So
I have a sort of related question. So that's a program that's sort of you're hoping to engage with, and I guess my sort of somewhat related follow-up is if you're keeping data on existing interaction outside the court with children or families, whether that be in facilities or within their families, or if there's any information about sort of that. Okay.
I wish we could, but because we are not involved at that stage, we don't have anything to keep. But right now, by statute, our office only becomes involved at the point where a petition is filed.
Right, and this is why, and so I wasn't clear, this is why I said I'm sort of adjacent to, but when you are involved, I would imagine that in these complex family cases, there needs to be a fair amount of support outside the courtroom.
Oh, yes.
And are you keeping data on what that support is looking like for families who are currently involved?
Certainly. In fact, we can sort that on in so many ways, because that's out of all the things that there's bad record keeping about, and I think we really improved things in the DG's office, especially since we moved to our new Radicalogics case management system. But we've always been able to do that piece of it because all of those services are paid for. And so I can go in on a financial report, and I can do it case by case, individual by individual, attorney by attorney, to see, in an individual docket number even. So even where a person might have more than one case, I can see which resources were assigned in any given docket number within their larger scope of cases, or I can see which services were assigned to that individual and all their docket numbers across any county. That data is certainly our office use. So in 2018, when that Title 40 money became available, we started the process of trying to get access to it. We drafted a memorandum of understanding with DCF, which is the first stage of that process. We modeled that memorandum of understanding off of the Connecticut memorandum of understanding. And we did that because Connecticut was the first state in New England to get their MOU approved by the Agency of Human Services. And because we're in the same federal AHS district as Connecticut, we figured if we modeled our MOU off of theirs, we would also get approved. And we got that signed by both our office and DCF. We were at the point of submitting it to AHS for approval, but we were told we can't actually do it because DCF's IT infrastructure doesn't allow them to differentiate between 40 eligible families and non-40 eligible families, and therefore we wouldn't be able to draw down on the funds that we wanted to draw down. So at that point, we switched our focus from drawing down 40 funds to supporting the DCF's efforts to modernize their IT system because we want those funds. And at that point, we were of the understanding that the only way to get those funds is if DCF modernized their IT system. And that was true at that point. What happened in the next few years is every state that could start drawing down those funds started drawing down those funds. So I think more than 30 states are now drawing down those 40 funds. There was other states and jurisdictions in the same boat that we were in that didn't have good enough IT systems to do the reporting and compliance to draw down those 40 funds. And so a private organization, a private organization sort of popped up to, or a private company, I should say, a for-profit private company popped up to fill the gap. So last year, actually year before last, we were approached by a private company that said, hey, we see that you guys are not drawing down 40 funds because you don't have the DCF reporting tools that you need. We can provide those tools for you and help you draw down those 40 funds. So we started working with them. We had several meetings with them, and we're at the point of signing a contract with them where they would essentially provide the IT infrastructure that DCF can't provide when it comes to compliance and reporting that would satisfy the feds so that we can start drawing down that money. And they do that for a kind of money. It's part of their, that's how they make money. And we are proceeding down that road because we want to start drawing down these funds. We are at the point right now of being prepared to sign a contract with them. They provide us with a contract. Like, we've determined the scope of work. They have interfaced with DCF several times. They are convinced, and DCF is convinced that this can work, that, that they will be able to make their systems work for DCF systems, and that they will be taking, that they will take liability for the compliance and reporting when it comes to the feds, so the DCF is not assuming any liability for that. And we're signing a contract with them. They proposed a contract, we're reviewing it. It then has to go to the Attorney General's office for review. I think the contract's coming in under the amount, so we don't have to go through the RFP process. Yes.
Just as a time check, we only have about 2 minutes left. Are you almost at your conclusion?
Almost at my conclusion. And the answer is yes, our office is paying for that, and we believe that the idea is the contract will pay for itself. So it shouldn't cost us a penny of new money. This organization is confident enough that they will be able to identify reimbursements and collect reimbursements and then pay kind of those reimbursements. And so they don't charge us anything on the upfront, which is helpful for us because we wouldn't be allowed to spend money on that upfront. And they understand that, which is why they structure the system this way. So the idea that we are not pursuing Title 40 funds to expand the scope of services that we present is also inaccurate. And just a sort of an update on from where we were before to where we are now, what we've been told is that we really would have to change those 3 things because all over the country, AHS is really approving the same 3 items in people's memorandums of understanding, which are recruitment, retention, and training as one item. Pre-petition representation, which was one of our items, as another item. And I forgot what the third one is. I just blanked out of my mind. But so it's already locked in what the 3 items will have to be. But that's our goal, is to pursue that Title 40 funding using this organization, Justice Benefits Incorporated. And to have that done, we're hoping within the year, at which point, if we are successful at identifying some past expenditures we'll be able to draw down, not just for future years, but 2 years of past expenditures also. Which means we could really hit the ground running with some of these programs. Now, one of our concerns about this provision is that this provision might make it less likely that this organization is willing to work with us. We were on track to be essentially signing a contract and pursuing this 40 money now, or even earlier than that, this spring. Since this bill came up, and there's now a question about, is there going to be an oversight committee looking at the provision of 40 money in Vermont? They want to see that resolved before they want to contract with us. So we're sort of waiting to see how this resolves before we can sign that contract. I do want to agree with one of the sort of kind of central conclusions that I came to in hearing the testimony about this bill and the questions about this bill in House Judiciary, which is, I do think there's a real lack of legislative oversight in the CHIN system. The questions that were asked in the in-house Judiciary really reflected a complete lack of understanding of the CHIN system, and in particular of parent and child representation within the CHIN system. And I think that a lot of the reason for that is that 2 years ago, we had a joint legislative child welfare oversight committee. It was usually chaired by Ann Pugh and Big Sears. And both Ann and David are along with members of this body. And it was a really robust oversight committee. It was fantastic. It met regularly summer and fall, just like Joint Justice Oversight does. It usually met 4 or 5 times. And they dealt with all kinds of issues and took all kinds of testimony. The meetings were day long, and so they incorporated everything. It was an incredibly great resource. And that collapsed. We were told that their responsibilities were handed over to Justice. Joint Justice has not held a single child welfare hearing since that happened. It's our office's opinion that this provision bill should be struck, and the Joint Legislative Child Welfare Oversight Committee should be brought back. It was a great committee. It created an interface between the child welfare world and the legislature. It had the Senate and House members on it. And it was a real measure of accountability for DCM, for our office, for the state's attorneys, for the Attorney General's office, and for all kinds of outside players also.
Marshall, that is the bell for us. So
Okay. I will just squeeze in a few more words, which are at the same time, the Justice for Children Task Force collapsed. That was a judiciary committee. It had about 30 members. It included legislative members. I don't know why it collapsed. It just stopped meeting. And finally, I just want to say that I submitted an article that's in today's documents. It's about the importance of independence of the defense bar within the judicial system. The independence of the judiciary is an independent branch of government goes without saying, but it was an article by Chesapeake, the chief public defender from San Francisco, about the importance of independent oversight of public defenders and defense attorneys in general. And I think that's also a very important component of considering this provision. And I'll leave it at that.
Thanks.
Thank you.